Yeah, I know there was a big mix-up with my camera today, so they gave me this.
Is this a, what is this? I think it's a 350, right?
It might be. I think so. I think you're right on that. So I've been going crazy all day, just trying to figure it out. I think this is more complicated than my big camera.
In ways, yeah. Well, I've used Panasonic for a long time, and they're great, but the menus are deep.
They are deep, which is what, like, for instance, like the audio was so low, I had to go like deep in the menu to really add gain to it.
Yeah,
you
yeah,
know,
yeah.
so yeah, I just kind of.
And if you haven't been in there a lot, it's
My
can be
first day.
nerve-wracking.
Yeah.
Got to do this. What are you doing Friday?
So just this, they said there was no plug-in.
There is. I can show you real fast.
Yeah, I have my XLR.
You may have to see if it's Mike. Meet me over there. With I mean, where you are.
Now, open and be seated. My name will make sure your cell phones off and put away.
Judge 22 CR 117, the Commonwealth versus Karen Reed. Can I have the parties for this motion identify themselves for the record, starting with the Commonwealth?
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
And the moving party?
Good afternoon, Your Honor. John Albano for the moving party.
Nice to see you, Mr. Albano. So before we begin, I did receive this morning a motion from Ms. Reed's counsel asking to waive her appearance today, as well as her counsel, stating that she takes no position on the motion and does not wish to be heard on the motion through counsel. I allowed that motion. And I also want to let you all know that when I read Mr. Albano's pleading, it was clear to me that the U.S. Attorney's Office was an interested party. So I, as you know, ordered the moving party to give notice to the U.S. Attorney's Office if they wanted to come here and be heard. They have sent a letter to me this morning that was docketed and put in the file, and they're not here to address this motion. So with that, I will hear from you, Mr. Albano.
Thank you, Your Honor. I don't want to repeat what I put in the brief, so
That's okay. Say whatever it is you want to say.
I thought maybe I should focus on the two issues that I expect are most significant here. One is, it seems clear that the impounded materials do include some grand jury materials, and obviously there's a general rule of grand jury secrecy. That we would submit is not always the case. If a witness is impeached with grand jury testimony, the trial isn't closed. If there's a perjury conviction, or perjury trial rather, that's not closed, even if it's based on grand jury testimony. And here, we submit that the detailed opposition, the 49-page opposition to the defendant's motion to dismiss, contained a significant amount of references to grand jury testimony. So I can't pretend I know what's in the impounded papers, but it does seem reasonable for me to suggest that that disclosure does mitigate the extent to which the rule of grand jury secrecy applies. And the other factor I would cite here is that these materials were submitted to the court as grounds for a ruling by the court, which the court made in denying the motion to dismiss the indictment. So to that extent, it is that the materials are sort of the classic judicial document which the public has a right of access to. And the last thing I'd say on this is that, again, I haven't seen what's impounded, but the alternative argument I'd make is if there is some type of sensitive grand jury material which has not already in substance been disclosed, then an alternative available is to redact just those portions of the documents and allow the rest to be made public. So that's sort of my pitch on the grand jury issue. The other issue I seems to me is relevant is the fair trial rights with a trial coming up and a disclosure of what has till now been impounded material if it's not in substance the same as the Commonwealth's opposition. And obviously there has been a lot of publicity about this case. That's just true. But the SJC has said that even in high profile cases, voir dire and jury instructions can be sufficient to protect the defendant's fair trial rights. The other two things I'd say here is I think it's significant that the defendant apparently has said she takes no position on it. So there's less of a concern, I'd say, about the defendant's fair trial rights being prejudiced. And from a legal perspective, I'd also say this. There is, and we put it in our brief, case law that says a closure order, an impoundment order should be effective at what it's trying to do. And in the fair trial context, the Press Enterprise case we cited, in that case, it was whether a pretrial hearing was going to be open or not. And the trial court judge closed the hearing, finding that there was a reasonable likelihood that an open hearing would prejudice the defendant's fair trial rights. And the U.S. Supreme Court said, you have to go higher than that. It has to be a substantial probability that the defendant's fair trial rights would be prejudiced and that the closure order will be effective. And here I would say that given the publicity that this case has engendered, the notion that the incremental effect of releasing the motion papers on the motion to dismiss, that would pose a substantial likelihood of a threat to the defendant's fair trial rights. I'd say, again, I don't have the benefit of seeing the papers, but we'd suggest that's not sufficient to justify a continued impoundment order, given the Commonwealth's filings and given the filing and given the fact that the motion has been ruled on.
All right. Thank you very much. Ms. McLaughlin, I know I have nothing in writing from you, but I know that you're getting ready for trial on Tuesday.
Yes,
So
Your Honor.
that's fine. I'll hear you.
Your Honor, essentially the Commonwealth takes no position on this motion. The Commonwealth received the confidential federal materials pursuant to a signed protective order that the Commonwealth has signed, that all filings made to this court that reference or include any references to the federal investigation would need to be filed, impounded, and under seal. Therefore, that what the Commonwealth has done as it is a party to that protective order. Your Honor, I'm unaware if we've previously filed the protective order. If Your Honor has not received that, I can file that.
I have not.
Okay, then the Commonwealth would move to file the protective order pursuant to an impoundment order of this court.
Are you going to come back in on that, Mr. Albano?
I should look at it first.
Your Honor, within the protective order, it does reference the jurisdiction of any disputes arising out of the protective order would be before the federal court. Therefore, essentially, the Commonwealth takes no position, but is bound by the federal protective order that was endorsed by Judge Casper on February 20th, 2024.
I'll hear you, Mr. Albano.
If I have it straight, then the Commonwealth's there is a distinction between documents filed with the court and documents in the custody of the Commonwealth and the defendant. And I wasn't aware of Judge Casper's protective order, but typically, in my experience, the protective order says you, the parties, cannot release this information. And this one apparently said, and by the way, if you file it in court, you should file it under seal. Having it been filed with this court, however, it is this court's papers, not the federal court's papers. So I don't, while of course one would take into account the federal court's protective order, I would say, and God, I hope I haven't read it, so I might be wrong, but I would say the protective order binds the parties, not this court.
The protective order indicates that not if we file it, we should impound it, that if we file, we must impound.
So that's been done already.
That has been done, Your Honor.
All right, does the Commonwealth, I would like the Commonwealth to address the concerns that we have on me releasing these state court pleadings. Are you bound by the protective order such that you can't even address that because they tell you that you have to go to federal court to address that?
The way the protective order is written indicates that if any party seeks to modify the protective order, the exclusive jurisdiction would be within the federal court.
So neither party is seeking to modify the protective order.
The Commonwealth has not sought to modify any protective order, nor has any party filed a motion to intervene in the federal court or seek this material from the federal court or address the motion before the federal court.
So why don't I have the authority to hear you today on the release of the state court materials that you filed, but I have referenced in my decision?
The Commonwealth, can essentially takes no position on what your authority is and what your role within the state court is. The Commonwealth can only represent what order it is bound by.
So, Ms. McLaughlin, I want to hear you on whether or not there is a docket number 201 that are the Commonwealth's grand jury minutes. What's the Commonwealth's position about me releasing those?
The grand jury minutes?
Yes.
The Commonwealth would oppose the release of any grand jury minutes prior to trial. The trial is imminent. These same witnesses who testify before the grand jury are anticipated to testify within the upcoming weeks. The release of their testimony prior to that trial may, don't want to cloud anyone's memory or anything that they previously testified to. The public will have the right to all that information when the witnesses take the stand. Under Massachusetts law, grand jury minutes are secret, and the Commonwealth would oppose any, release of the materials that went before the Norfolk grand jury.
Okay. So when I read Mr. Albano's motion, I focused on the paper numbers that he cited, or everything that the Commonwealth and the defendant filed under seal. You all followed your protective order that I do not have to follow. You all followed the protective order. And I considered those materials and I referenced them. They were critical in my decision, and I referenced them in the decision. So that's what I am focusing on.
If those portions, whatever, Your Honor, its findings, the public has the findings made by the court. The witnesses would testify to that, their personal knowledge shortly. So the Commonwealth, as in any case, would object to the release of any grand jury minutes.
But regarding the pleadings?
Regarding the pleadings, if Your Honor is inclined to release pursuant to this motion that the Commonwealth, really does take no position on, redactions could be made to any references of grand jury materials that, the Commonwealth takes no position on what Your Honor's authority is, but to the point that when we filed the materials, we were bound by this protective order.
So they were impounded.
Yeah, so perhaps the redactions may be appropriate. It's a unique circumstance.
It is a unique circumstance, and I understand the position that the Commonwealth is in, and I understand the position the defendant was in and prudently decided not to pursue anything in court, but you had no choice. You had to be here. So, Mr. Albano, do you believe I have the authority to do with these documents that you've requested what I want to do with them and what I think the Massachusetts law governs?
I do, Your Honor. I think, again, I'll go back, track down that protective order, and I'd be happy to submit a supplemental filing. But as I stand here today, I don't understand how a federal court judge can tell a state court judge what to do with the state court's files.
For a case that's on for trial next week. So I share your view. I do not have any case telling me that I have to listen to what they say I should do with this case. And I'm not going to put the Commonwealth in the position to ask them whether they agree with me
Please, no, Your Honor.
or not. So as you all know, this case is going to trial next week. So although the Globe recognizes the secrecy of the grand jury proceedings, it is requesting that this court unimpound 14 days of grand jury testimony on the basis that some grand jury testimony and exhibits have been disclosed in a public court filing, and therefore the interest in grand jury secrecy are overcome by the public's right of access to court records. While it's true that some grand jury testimony has been previously disclosed to the public, I can tell you because I've read them, the majority of testimony and exhibits have not. In particular, the request encompasses videos of SANE interviews and testimony of witnesses not mentioned in any public filings. So although the SJC has recognized that a limited amount of disclosure of grand jury testimony may be justified when there has already been public disclosure of that information, the Globe has not directed this court to any case law suggesting that where some grand jury information has been publicly disclosed, all grand jury testimony and exhibits lose their secrecy. And that point is clearly made in a case that, the Carol DeMady Stewart case. So the Globe newspaper versus police commissioner of Boston. It's a case that plaintiff's counsel was Mr. Albano. So should the Globe seek grand jury testimony of a specific witness whose testimony was summarized in public court filings, the court would consider such a request. However, the only part of the witness testimony, my reading of the case law, that would be subject to disclosure is that which has been summarized in a court filing. So I am prepared to release subject to redactions, and as if you don't have enough on your plate, Ms. McLaughlin, I am going to give the Commonwealth until tomorrow morning at 11 o'clock to make proposed redactions. The defendant has waived any argument to this motion, so it's up to the Commonwealth. So I am inclined to release paper 199, which is the defendant's motion to dismiss. There are attachments to that by way of exhibits that are with it. I am not going to release what's docket number 201, the grand jury minutes. I am not going to release the grand jury minutes. I am going to release paper number 228, the supplemental memorandum in support of defendant's motion to dismiss, though it has actually a different heading. And I'm going to release the Commonwealth supplemental memorandum in opposition to defendant's motion to dismiss, docket 232. So it doesn't give you a whole lot of time, Ms. McLaughlin, and I do know just that there were police reports attached to the motion to dismiss the Odell motion.
Okay.
That include dates of birth and addresses of witnesses, so I will redact those. Certainly, you're not interested in those, Mr. Albano. So I need to redact any identifying information, and what the Commonwealth might think should not be released pursuant to this order. It doesn't stop you from filing a motion to intervene in the federal court, obviously, for anything else. All right.
Understood.
All right. Okay, can you get it to me by 11 o'clock tomorrow morning?
Yes, Your Honor.
Thank you. All right, thank you very much.
Thank you, Your Honor.
All right, so Jim, we're going to take a recess before we do our other stuff,
Okay.
okay? Tori, we all set? I can take my computer? Thank you.
All right, please.